Well, that was terrific. It's a privilege to be here this morning. I want to begin by thanking Bob for the invitation. I appreciate this opportunity, and I'm grateful for the work that you and of course Cole Durham do, and all the others who have worked to put this conference together. And this is an important gathering, and in the years to come it's going to become even more important. It's going to become important for people to get together and to talk about these subjects and to debate and to seek understanding and then try to figure out how best to proceed. So I'm grateful to be a part of this morning. And I'm grateful for Jean. Thank you, Jean, for your presentation of the Supreme Court's recent same-sex marriage decision and its sobering implications. But more importantly, thank you for the sacrifices that you've made on behalf of traditional marriage and the cause of religious liberty. Gene downplays those sacrifices. They're actually quite real, and he's a tremendous example to all of us as one who has and is standing as a witness for the things that he believes. We're all going to have to do a lot more of that in the months and years to come. How many of you, by a show of hands, are not attorneys? Oh wow, that's wonderful. How many of you attorneys kind of wish you weren't attorneys? No, just kidding. I asked that question because I want to spend time talking as much to non-lawyers as to the lawyers among us, because as this conference reminds us, it is high time that the issue of religious liberty cease to be primarily a legal issue to be debated by lawyers and law professors and judges. Religious liberty is as much about our culture and how we live together as free and equal citizens as it is about legal theories and lawsuits. And how we live together is not ultimately for lawyers, law professors, and judges to decide. That is something that all of us, we the people, are going to have to figure out for ourselves. The question this panel has been asked to address is, what will be the effect on religious liberty of the Supreme Court's gay marriage decision? And I'm glad we've sort of come to a consensus that it's pronounced Obergefell, because frankly I had no idea how to pronounce the thing. And I have an absolutely certain answer for you. The answer is, it depends. It depends on how our culture and how our society react to the decision, and how in turn the law reacts to those cultural and social changes that will be unleashed by this decision. Now let me venture for a moment into judicial philosophy, or at least my version of judicial philosophy. I always wanted to be a law professor, so you kind of look like a law school class, and I'm going to pretend for a moment that I am. To use a really abused word, our culture and the law are in a symbiotic relationship with each other. In fact, if there's one thing that has become abundantly clear from the Supreme Court's same-sex marriage decision, it is that when it really counts, constitutional law is as much about culture as it is about the Constitution. Many of us have this image of our judicial system where judges sit in their dusty chambers dispassionately scrutinizing legal texts in light of objective tradition and history and legal precedent. And then after much study and searching, they come to carefully reasoned conclusions that allow them, in the words of the great Chief Justice John Marshall in Marbury versus Madison, to say what the law is. They have this eureka moment, and there it is, the law appears, and they declare it to the people. And that may well be accurate to an extent, in many cases that judges tend not to care very much about personally, such as fights between powerful corporations over intellectual property rights and contractual rights, or tax disputes, or any number of other legal areas that judges routinely deal with. But when it comes to novel issues of constitutional rights, including matters of religious liberty, there's often much more going on than just judging. Constitutional law in these kinds of cases is often, not always, but often, a lagging indicator of elite opinion, elite cultural opinion, tempered by the broader American culture. In other words, over time, the legal and cultural elite come to a conclusion about what the Constitution requires in such matters, and then judges, who are part of that legal and cultural elite, tend to adopt those views, provided that they do not lead to conclusions that are too inconsistent with American culture and expectations. Hence, although much of the legal and cultural elite had concluded well over a decade ago that same-sex marriage should be a constitutional right, it was not until this year when at least half of the American people, according to some polls, seemed to support gay marriage, that the majority of the Supreme Court justices felt free enough to issue a decision finding a fundamental right to same-sex marriage. Again, in these sensitive constitutional areas, culture often drives constitutional law as much as the words of the Constitution and legal precedent drive constitutional law. And conversely, it is also true that constitutional law drives culture. They have a relationship that goes back and forth. The law itself is a teacher. There is a tendency, for example, for people to believe that what the Supreme Court says the Constitution requires is in fact what is right and good for society, and that any opposition to that is by nature wrong. Thus, culture affects law, and law in turn affects culture. Okay, that's my little piece on being a law professor. I'm not sure how well I did, but here's the question. What on earth does this have to do with the religious liberty in the aftermath of the Supreme Court's same-sex marriage decision? As it turns out, it has a lot to do with it. I believe there are two very different paths that our culture, and hence our law, can go down when it comes to the religious liberty of those who sincerely believe as a matter of faith and faith-filled reason that marriage is and should remain between a man and a woman. These are two kind of models, I think. And these are kind of rough approximations. No model is exactly right, but something to think about, because we've had experience in some of these controversial areas before. The first path or model would be analogous to what happened after Brown v. Board of Education and Loving against Virginia. It is the path that we as a nation took when it comes to race and racism. As you know, after a long struggle that included the Civil War, 3 amendments to the United States Constitution, and heroic efforts by thousands of civil rights activists and ordinary citizens, in 1954, the United States Supreme Court unanimously held in Brown v. Board of Education that state-sponsored racial segregation violates the Equal Protection Clause of the 14th Amendment. This ruling paved the way, of course, for racial integration and the dismantling of the Southern apartheid regime. And then, as almost a capstone to a series of civil rights decisions, in 1967, in the case of Loving against Virginia, the Supreme Court again held unanimously that laws against interracial marriage also violated the 14th Amendment. As vitally important as these cases and these Supreme Court decisions were legally, they had a profound effect culturally. Together with laws passed by Congress, they of course made racist actions by government unlawful. But far more profoundly, they also contributed to a culture that made racist speech and even racist ideas by individuals socially and culturally taboo. Yes, the First Amendment still protects the right of racists to spout their hatred from the street corner, but if you do so, you will be a social outcast. In most communities, you are likely to be terminated from your employment by one means or another, if you can find a job in the first place, and you certainly won't have a legal career to speak of, and you can forget about playing, in most communities at least, any active role in the political or social life of your community. Now that, of course, is all well and good. Racism was and is a scourge, and we properly attach very severe social consequences to those who engage in it. My point is simply that there is very little real freedom or social space in which to be a racist. We've essentially said, we don't want that among us, and we will exclude it, marginalize it, and keep it out of our midst. If the Supreme Court same-sex marriage decision results in support for traditional marriage being equated culturally and legally with racism, then as a practical matter, religious liberty will be severely restricted. Under that model, government itself will come to have powerful justifications for suppressing and marginalizing religious beliefs, speech, and especially actions that challenge the new right to same-sex marriage. Schools will be expected to instruct children in the new marriage ideology and to suppress speech and beliefs that run contrary to it, just as schools do now when it comes to racist speech and viewpoints. The expression of pro-traditional marriage viewpoints within the workplace will be seen as harassment that cannot be tolerated, even as pro-gay marriage viewpoints are openly discussed. There will certainly be no right to avoid providing services to activities related to same-sex marriage, such as photography and as Jean said, the butcher, baker, and candlestick maker. And institutions, including churches and religious schools and universities that have sexual teachings and standards rooted in traditional marriage, can expect eventually to have their tax-exempt status challenged. Indeed, if support for traditional marriage is equated by our society and culture to racism, then really every negative outcome that Jean just warned about and worse will become a very real risk. But there is another path or model that things might go. In 1972, in Roe v. Wade, a divided Supreme Court removed the issue of abortion from the democratic process, declaring that abortion is, as the Supreme Court declared with the same-sex marriage case, a fundamental right during the first 2 trimesters of pregnancy. What followed could have been something like the aftermath of the Brown and Loving decisions, where anyone who questioned the right to abortion would be driven out of polite society and marginalized socially and legally. There were certainly cultural forces in place to push that kind of an outcome, but that didn't happen. Today, it is entirely possible for a strong pro-lifer to be open and frank about his or her beliefs in public, in the workplace, at school, and in the various other areas of life. Now, of course, there may be severe criticism in some quarters and even angry and passionate debates, but one does not become a social pariah for conscientiously stating positions against abortion. Indeed, various laws and court decisions protect beliefs, speech, and even actions that oppose abortion. If in the aftermath of the same-sex marriage decision our nation follows something like the example set in the aftermath of Roe v. Wade, then religious liberty will survive and in fact probably do quite well. There will be hard times, to be sure, but eventually there will be accommodations for those who honestly dissent from the new gay marriage orthodoxy. So for me, a critical question at this juncture is, how is it that opposition to abortion was able to secure a place of respectability in our culture and law? How did we get to the place where you could be a pro-lifer and still have a career and still be open, still express your views, and not become something of a social outcast? Now, the answer to this question is no doubt complex, and as Jean has pointed out, the language of the Supreme Court in these kinds of decisions does make a difference, what theory the Supreme Court used, and in the case of Obergefell, the Supreme Court used a fundamental rights theory, which is very similar to the one used in Roe v. Wade. That is a potentially a good sign. But assuredly, one of the key reasons is that religious and other pro-life voices, including, of course, pro-life Catholics and evangelicals who really took a leadership role in this area, decided that they would not, indeed could not, remain silent. They spoke up. They refused to be intimidated. They organized. They insisted on their rights of free speech, and they learned to make their case with reason, civility, and even love. To be sure, there were extremists within their ranks, those willing to disregard the law and even commit terrible crimes. They had to be denounced and removed. There were missteps, there were mistakes, there was retrenching, but eventually the pro-life movement found its voice and succeeded in convincing about half of the American people of the rightness of their beliefs. Of course, not much has changed legally. The Supreme Court still insists that abortion on demand is a fundamental constitutional right, so Roe v. Wade has not been overturned. Nevertheless, the fact remains that those opposed to abortion can still be full and equal citizens, participating in all walks of life, from school teacher to business person to lawyer to President of the United States. That is very significant. The right to be a pro-lifer has very much been preserved. In my view, the effect of the Supreme Court same-sex marriage decision on religious liberty will depend to a very great extent on people like you and me. If supporters of traditional marriage retreat, if they are intimidated into silence, if they give up trying to find the right words and arguments to defend their beliefs, if they do not stand as witnesses and living examples of the goodness of their beliefs, and if people of goodwill do not at least stand up for the rights of others to dissent in good faith, and yet still be numbered among us as our fellow citizens, neighbors, colleagues, and friends, then the Supreme Court's gay marriage decision will indeed become a disaster for religious liberty. But if those who support traditional marriage are indeed examples of what is highest and best about their beliefs, if they, like the pro-lifers, refuse to be silenced, if they find ways to explain and persuade with reason as well as kindness and meekness and love, and if they cheerfully but resolutely endure the indignities that will indeed be visited upon them without bitterness, asking only for toleration, understanding, and their basic rights as Americans, then I believe that ultimately the great goodness and decency of the American people will rise up, and our culture and law will carve out and protect enough spaces so that people of faith and their institutions who maintain traditional beliefs about marriage, family, and sexuality can participate fully in all aspects of American life. Now, that will not happen all at once. Those of us who hold such beliefs are assuredly in for some difficult and uncertain times. Sacrifices are going to have to be made. Carefully chosen lawsuits will have to be filed. We may even lose some friends on Facebook, or maybe even some real friends. But I am hopeful that in the end, if we stand firm, both our culture and the law will accord those who believe in traditional marriage the respect and freedom they deserve. Thank you.